Kevin Hague.
For the benefit of the hands out record, I've just given the sign for kia ora that I learnt from the New Zealand Sign Language website this afternoon. It'll be a challenge. Mr. Speaker, I want to begin by expressing the sympathy of the Green Party to Heke Parata and to her whānau. Mr. Speaker, so far in this House, my speeches have often focused on the need for a Green New Deal, a range of actions by government to help people cope with the effects of recession that also address the urgent challenges of climate change and other environmental problems that cannot wait. If it's possible to do both simultaneously, why on earth wouldn't we? But the Green Party has some other priority areas for action, and today in relation to this bill, I'm going to be touching on a couple of these. I speak today on behalf of my colleague Materia Ture, who cannot be in the House today. The need to protect our natural environment in the interests of our kids, and the need for healthy politics, including the Green Party's charter principle of appropriate decision making, are also foremost in our minds. The bill is designed to improve regulations and the compliance burden for businesses in a range of areas, a process we heartily endorse, and I should say for the record that the Green Party will also support the omnibus bill process. However, despite claims by government that this bill only contains minor and uncontroversial changes, we disagree. In particular, we are opposed to the changes to the Conservation Act, the Reserves Act and the HASNO Act, and therefore with regret will be opposing the bill. Government says that the measures contained in the bill, and Joe Goodhue has already mentioned some of these, address regulatory duplication, gaps, administrative errors and inconsistencies between different pieces of legislation. Clearly a laudable aim. But unfortunately, while many of the measures, indeed most, contained in the bill do meet this prescription, others do not, and would have been much more appropriately dealt with in separate legislation. Even though there is an intent to break the bill into separate pieces at a later stage of its process, that is not an appropriate way of managing substantive change proposed. Firstly, we do have concerns about the implications of some of the proposed changes to the HASNO Act. Some of these changes do meet the criteria government has set out, while others do not. For example, the proposed changes to delegations, they do not meet those criteria. Our co-leader, Jeanette Fitzsimons, has been closely involved in this area of law, and we will be considering the submissions made on this aspect of the bill with a keen interest, should it proceed. This speech, however, focuses on our concerns about the proposed changes to the Conservation Act and parallel measures proposed for the Reserves Act. Conservation law is an area where conservative, with a small c, approaches to change are most needed. Yet the changes proposed in this bill do not fit the technical and uncontroversial test at all, but rather have been incorporated into this bill for entirely opportunistic reasons. The amendments to the Conservation Act are designed to reduce the costs and administrative burdens of the concession provisions by amending the current provisions to allow concessions to be granted for a term of up to 10 years instead of the current limit of 5 years, and introducing a discretion not to publicly notify the intent to issue such concessions. We are opposed to these proposed changes. Conservation land is extremely important to our tourism industry and will become increasingly so. It is also very fragile land, and many areas have very important values. While the recreational and tourism use of conservation land is an important purpose in the Act and in New Zealand culture, the protection of that land and its fundamental intrinsic conservation values is the highest priority. Extending the maximum period of a concession reduces the ability of the Conservation Department to oversee, review and manage any detrimental impacts of the concession. We note that the Minister will have the ability to seek a mid-term review of a concession. However, that will most likely require some external organisation making complaints and following up a long and bureaucratic process to seek the Minister's agreement to require such a review. Retaining the 5-year maximum ensures that every concession is reviewed within a realistic time frame, allowing for better quality assessment of the impacts of the operation on the habitat without ministerial intervention. And the reality is that if a concession application is for a 10-year duration, it will be very difficult for the department and for conservation boards, and I should inform the House that I've previously served on the West Coast Taipotiri Conservation Board, to make decisions about conditions with any degree of certainty as to likely impacts. The consequence will inevitably be heightened risk to conservation and recreation values. Some increased pressure effectively will also come onto conservators and boards to consider further applications or to vary conservation management strategies or national park management plans, as potential competitors are excluded by longer-term monopolistic licences. If an operator can't undertake the activity he or she was hoping to for 10 years, they may put the pressure on to create a new opportunity. As public conservation land and amenities face increasing pressure from concession activities, the inevitable consequence is loss of wildness and erosion of the important values and features that led to this land's inclusion in the conservation estate in the first place. The current 5-year maximum term provides greater protection of the conservation estate and the public interest in it. In addition, there is a high level of discretion as to whether a concession application is publicly notified. The risk of the public being shut out of the decision-making process is heightened, as the Bill's provisions make the public's involvement in decision-making more contingent and would reduce the frequency with which the public may have the opportunity to express a view. This is inappropriate decision-making process. As the land in question is public land, the public interest should have a greater level of protection. The precautionary principle should be applied in the case of managing concessions. By extending the time frame and increasing the discretion around public notification, it will be more and more difficult to identify and remedy the impacts of concessions. I note that the longer maximum durations for concessions proposed by the Bill set out to reduce the administrative costs faced by concession applicants and holders. Members need to note that the Department's cost is in no way reduced, as all costs are recovered from applicants. So the benefits are all accrued by concessionaires with less cost and exclusion of competition, while the costs for the New Zealanders who own this conservation land are increased risk to conservation and recreation values, less public involvement in decision-making, and potentially the loss of better ideas, those potential concessions that are locked out of the concessions process by the longer-term licences. We note that these proposals arise out of the 2004 concession review project and that a number of environmental NGOs were consulted. Of course, that doesn't mean that they supported the outcomes, and should this bill advance, the Green Party will be paying close attention to the views that NGOs wish to express. But, Mr. Speaker, these provisions concerning the Conservation Act represent just a fraction of the recommendations of that review, advanced at this time for opportunistic reasons. We're concerned that changes to the concession process are being made in a piecemeal fashion. The conservation estate is too important for this kind of lawmaking process, and Parliament should instead be seeing together all of the proposed changes and making decisions on the integrated package. These provisions have been inappropriate inclusions within this bill and carry substantial risks that they have not been appropriately canvassed and will not be by the process proposed for this bill. For these reasons, the Green Party will oppose the bill, but offers to work with government and other parties to find a formulation for the bill that would really be uncontroversial and attract the support of all members of this House. Thank you.